Welcome to S&C's podcast series, S&C Critical Insights. I'm Annie Ostrager, a litigation partner in S&C's New York office, the co-head of our labor and employment practice, and a member of our criminal defense and investigations group. With me today is George Sampas, a partner in our mergers and acquisitions group, who leads the firm's aviation and North American energy and natural resources practice, and Amanda Davidoff, a partner in our Washington, D.C. office and the deputy managing partner of our litigation group. On today's podcast, we will be focusing on issues faced by the aviation industry arising from the coronavirus pandemic. First, we'll address the CARES Act as it relates to the aviation industry, and then we'll discuss certain legal considerations of which airlines should be mindful. Now I'm going to turn it over to Amanda to talk about what's provided for in the CARES Act.
Thanks, Annie. On March 27th, President Trump signed into law the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act, which authorizes the Secretary of the Treasury to make up to $500 billion in loans, loan guarantees, and other financial assistance in support of certain businesses affected by the coronavirus outbreak, as well as states and municipalities. The CARES Act authorizes $75 billion in loans and loan guarantees, as well as payroll support to companies in the aviation industry.
Amanda, what specifically does the CARES Act authorize in terms of loans and loan guarantees to the airline industry?
Title IV, Subtitle A of the CARES Act, also known as the Coronavirus Economic Stabilization Act of 2020, or CESA, authorizes the Treasury Secretary to use $42 billion for loans, loan guarantees, and other investments to three categories of participants in the aviation industry. First, there is up to $25 billion in loans and loan guarantees for U.S. passenger air carriers and related businesses, such as inspection, repair, and overhaul service providers and ticket agents. Second, there's up to $4 billion in loans and loan guarantees for U.S. cargo air carriers. And third, there's up to $17 billion in loans and loan guarantees for businesses critical to maintaining national security. An additional $454 billion in loans and loan guarantees is available to certain other entities affected by the coronavirus, but those programs are beyond the scope of our talk today.
George, what's required for a company in the aviation industry to be eligible to receive aid under CESA?
Basically, these have to be U.S. air carriers, or for non-air carriers, companies with most of their operations in the U.S. And these companies' continued business operations must be in jeopardy because of the coronavirus pandemic. Air carriers are not just airlines. The definition under the FAA rules includes any business that transports people by aircraft. So that's the big four: Delta, United, Southwest, and American, plus all the other airlines, LCCs, and ULCCs, as well as charter businesses like NetJets and Blade and PlaneSense. And in order to receive the loans or loan guarantees, recipients must agree to restrictions on capital allocation, layoffs, and executive compensation. For example, aid recipients are prohibited from making stock buybacks or paying dividends for the duration of the loan plus 1 year. The $42 billion available in aviation industry loans under this portion of CESA are expressly not forgivable by the federal government.
The employee protections do, though, allow some flexibility for the aviation industry, right, George?
Right. Until September 30, 2020, a loan recipient must maintain its March 24, 2020 employment level to the extent practicable. If maintaining this level is not practicable, the business is permitted to reduce employment by up to 10%, but not more. These levels do not include people that have accepted voluntary furloughs. So you're seeing a lot of those. Notably, and different from certain other types of loans provided under the CARES Act, the federal government may not condition financial assistance on a recipient's implementation of measures to enter into negotiations with employees' certified bargaining representatives.
And there are also some restrictions on compensation that are targeted to executives?
Yes. There are restrictions on the compensation and severance packages for officers or employees who made over $425,000 in total compensation. That's salary, bonus, stock awards, and other financial benefits in 2019. There are additional restrictions for employees and officers whose total compensation in 2019 was over $3 million.
Let's turn now to the Payroll Support Program. Amanda, can you speak briefly about that?
Sure. In addition to the loans and loan guarantees made available to companies in the aviation industry, the Payroll Support Program, which was created under Title IV, Subtitle B of the CARES Act, authorizes grants to the aviation industry to be used exclusively for the continuation of employee wages, salaries, and benefits. This includes $25 billion for U.S. passenger air carriers, $4 billion for U.S. cargo air carriers, and $3 billion for aviation industry contracts. On April 20th, the Department of the Treasury concluded payroll support program agreements with various airlines, and many others have indicated that they plan to participate. Treasury also made the first payroll support program payments to passenger air carriers on April 20th, dispersing a total of $2.9 billion to approved applicants, including 2 major airlines and 54 smaller passenger air carriers.
And George, what conditions have been imposed in order to receive grants under Subtitle B?
Air carriers and related businesses and contractors are prohibited from conducting involuntary layoffs or furloughs or reducing pay or benefits until September 30, 2020, from making stock buybacks or paying dividends through September 30, 2021. And in addition, a grant recipient is also subject to restrictions on executive compensation, as we discussed. One of the most difficult to interpret requirements at this stage is that carriers have to continue operating to all points through September 30 to the extent reasonable and practicable as determined by the DOT. Under the guidance to date, a point is not an airport. So many airlines are interpreting this to allow consolidating operations at a single airport in a geographic area. For example, in New York, think about closing down at Westchester and Stewart while continuing at JFK and LaGuardia. Then there is a question of how often an air carrier needs to fly to a point. There are now 2 sets of criteria, one for the big 4, whose names we mentioned earlier, and a separate set for all the other carriers. On top of that is a question of when you measure the points you were serving, and that guidance allows carriers to choose their winter or summer schedules. And I'm sure that the guidance will continue to evolve. We've seen the photos of flights with only a passenger or 2, and we all think about whether that makes environmental or economic sense. A few final points on the grant program. As with the loans, the federal government may not condition financial assistance on an air carrier's or contractor's approach to collective bargaining. In addition, the government may demand financial guarantees in exchange for receiving payroll support.
Now, Annie, can you speak to some of the litigation risks that need to be considered in light of all of this?
Yes, the legal landscape is changing quickly, and as the coronavirus situation unfolded worldwide earlier this year, and in the U.S. during late February and early March, airlines, like the rest of us, were trying to keep up with the rapidly changing circumstances. The full scope of the litigation risk arising from the pandemic remains to be seen, but putative class actions have already been filed by U.S. passengers against both U.S. and international airlines asserting various types of claims. Private litigation could include, among other things, claims for breach of contract, unjust enrichment, violation of state consumer protection statutes, claims for fraudulent misrepresentation and unconscionability, or negligent or intentional infliction of emotional distress. There's also the potential for regulatory action. In the ordinary course, the U.S. Department of Transportation's rules regarding flight delays and cancellations apply only to flights that operate to, from, or within the United States. The DOT's rules require the airlines to provide a prompt refund when the carrier cancels the passenger's scheduled flight or makes a significant schedule change and the passenger chooses not to accept the alternative offered by the carrier. As the coronavirus situation progressed, airlines reacted by adjusting their schedules, which resulted in some canceled or rebooked flights for passengers. In these instances, many airlines offered certificates or credits for customers who could not engage in their planned travel to use in the future. Seemingly in response to consumer complaints regarding these certificates and credits, as opposed to full refunds, on April 3rd, the DOT issued an enforcement notice clarifying that in the context of the coronavirus public health emergency, U.S. and foreign airlines remain obligated to provide a prompt refund to passengers for flights to, within, or from the United States when the carrier cancels the passenger's scheduled flight or makes a significant schedule change and the passenger chooses not to accept the alternative offered. The DOT also took the position that the obligation of airlines to provide refunds, including the ticket price and any optional fee charged for services a passenger is unable to use, does not cease when the flight disruptions are outside the carrier's control. The DOT noted that due to the unprecedented impact of COVID-19 on air travel, it will exercise its enforcement discretion and give carriers a chance to become compliant before taking further action. The DOT noted that it will monitor airlines' refund policies and practices and take enforcement action as necessary. As with other industries navigating essential business designations and stay-at-home orders, there's also the possibility for employment-related litigation. You can hear more about these topics in other episodes of Critical Insights or read about these issues on S&C's employment blog.
Thanks, Annie. Today, we provided you with highlights of issues the aviation industry is facing in today's changing legal landscape. You can find more detailed information on the issues discussed on today's podcast on our website, www.cellcrom.com, under Coronavirus S&C Update. Thank you for listening to S&C Critical Insights. Be safe and well.